All right, welcome back to the podcast. Today we have a very interesting, very interesting guest. We'll get into his intro and everything he's up to in just a minute, but his name is Brandon Joe Williams. King, you're a king, right? King of the Amnesty Coalition
Yeah.
and a pickle. King of the
Yeah.
pickles. So, it's
Unique.
quite,
A little bit unique,
by
right?
far the most esteemed guest we've had the privilege of talking to. So
Thank you.
welcome on, man. Do you want to tell us just a bit about yourself and your research and what you're doing?
So I dig into the law and I find all sorts of goodies and then I organize them and figure out the separation between, domestic or national and international law and kind of how that all works. And then relate that into financial systems. I relate that into, citizenship and nationality. And basically that's pretty much the gist of it. I mean, I focus in those two areas. I focus in on nationality and citizenship on one end, and then financial instruments on the other end. So it's kind of like my two areas of specialty,
Yep.
I guess you could say.
And are they mutually exclusive? Do you have to be as involved in both as you are to research it and take action, enjoy the benefits of knowledge?
I'm not sure. We're trying to make it easier and easier. I mean, that's my job, so I'm always trying to make it easier. I mean, if you would have tried to do this 5 years ago, it would have taken you 10 years probably to get to where we're going now in a few months. So, I mean, in another year, we'll probably have everything down to, you know, 10, 20 years of what it would have taken 5 or 10 years ago could probably be done in a month, 3 weeks.
Yeah. So you mentioned it was your job. Let's talk a bit about that because you're a very interesting guy, Brandon. Like for you to do what you do and literally take on the entire matrix. I mean, that's basically what you're doing. Why? Like, who hired you to do this, man? No one hired you. Why are you out here doing this? And why do it all for free? Why even document it? There's other people in the space making a buttload of money, selling courses and whatever. So,
Well, I have the law firm, which is an international trust that's physically located in the nation of the Amnesty Coalition. So it's an international nonprofit, basically international nonprofit organization. It's hard to even use the correct terminology anymore. So I do procure a specie as well as negotiable instruments through that, meaning gold and silver coins as well as negotiable instruments, which means unconditional promises and orders to pay, such as Federal Reserve notes. But the mainline research and the courses and everything are all free, and all my flowcharts that I'm making now are free, and all the other research is free, and all my documentation is free. And then I try to, when it comes to lawsuits and stuff like that, there's something called ReCap. Most people are not familiar with this. ReCap is part of the Free Law Project, and it's just basically a little browser extension that you can get for free. And anytime anyone downloads anything from what's called Pacer is what you can get into to see any docket of any court case. So you just type in the name. Let's say, for example, you want to see if someone has been sued before or whatever. You can just type their name into Pacer, and it'll pop up and it'll show you the various cases where they're located. And then when you click on the case, you can actually go into the docket itself, and you can actually download the various items that are in the docket, such as communications going back and forth, such as you can see when hearings took place. You can download anything that was filed into the case for 10 cents per page. When you have ReCap installed on your browser, whenever you download anything, it goes into the Free Law Project's ReCap. And what that does is basically it allows anyone without a login, without having to pay, to access that particular docket item forever. I can actually show it to you because it's part of kind of what I do and why I make everything free and kind of how it all works. Can you see my screen?
Yeah, I see it.
So if we go to my website here, and go to current and previous litigation, and we go down to, let's say, for example, the City of Glendale case. So this is what recap looks like. But
So just to clarify, Brandon, whoever is accessing the Pacer, whoever has a Pacer subscription has to have recap, and then it goes into the system for everyone
yeah,
else.
so you can see here on recap, it says here buy on Pacer. So this particular document, no one has bought this document yet, so it's not in recap. But you can see when it's blue and it says download PDF, you can see I'm not logged into anything. There's no login. There's no anything. You just go right here. You find the docket item that you would like to see. For example, my original complaint. You go to download PDF and then boom, it gives you the entire PDF complaint straight from Pacer for free without having to do any logins or pay for the document. So even that we're trying to make free. We're trying to make everything as free and as accessible as possible for anyone and everyone.
Okay. I've heard you bring up the City of Glendale case in different videos. Specifically, the City of Glendale case. What is the argument about? What's the case about?
Um, so
In a nutshell.
Negotiable Instruments, which is a part of the free Contract Killer course. It's the third module in the free Contract Killer course. It starts on video 12, I think. Is a subject that is basically securities. Essentially, it's pretty much the same thing. They're a little different, but it's pretty much the same thing. Negotiable instruments fall into two categories: unconditional promises to pay and unconditional orders to pay. And when you start going down this rabbit hole, for example, you look at what's in your wallet, it says Federal Reserve note. Note means promissory note. Promissory note means negotiable instrument. Money is defined as gold and silver coin. Currency is defined as gold and silver coin, and it can also include things like promissory notes, unconditional orders to pay, etc. So we don't have money in our pockets. We have what's called currency. And that currency is they're basically securities, and they operate under all of the same laws as securities. So saying Federal Reserve note and saying a security, like what they trade on Wall Street, is saying the exact same thing. So when you understand that, you start getting into what's called the UCC 3, the Uniform Commercial Code, Article 3. And you can see here, this is basically the rule book. It's like, can you see my screen?
Oh, yeah, I see it.
So it's like, imagine a Monopoly rule book. You buy Monopoly, and then there's a rule book that comes with it. So this right here, the UCC Article 3, this is the rule book of the Monopoly game called Negotiable Instruments. Okay. And when you start to understand this rule book, you start to understand that you can literally just take what's called, so if you look at 3-104, and you can see here, like, for example, the way that the UCC works is the UCC is a model code. It doesn't become law until it hits the state level. So, for example, in California, it's called the California Commercial Code. Now, most states, it's the exact same thing as the UCC, the Uniform Commercial Code. So you can see here, if we go to the California Commercial Code, we go to Division 3, and then we go to Chapter 1. You can see here, if we were to go down, we were going to find all of the same terminology here. We're going to go down past the definition section. We're going to go to 3-104. So you can see here, negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order if it is all of the following. And then we have that exact same terminology here. Negotiable instrument means an unconditional promise or order to pay a fixed. So in California, they took everything from the Uniform Commercial Code and they made it law word for word at the state level. So when you sue someone, you would use this. You'd use the state versions of it, the California Commercial Code, but the UCC is just easier to look at, right? So a negotiable instrument falls into these two categories: an unconditional promise or order, right? So, for example, with my City of Glendale case, right, when you receive a utility bill,
Okay, so the City of Glendale case is specifically regarding like utility bills.
Yeah, so here's a utility bill. It even says on it municipal bill. Bill is a shortening for the term bill of exchange. And a bill of exchange is also an unconditional order to pay. You can see it. You can see they're unconditionally ordering me to pay 356.30 Federal Reserve notes or other U.S. tender by a certain date. Right? I crossed out that date and put payable on demand because you can do that. But basically, a bill is essentially an unconditional order to pay. Bill means bill of exchange. In the UCC, it means draft. So the term that you would use if you're talking about the commercial code would be the word draft. The word bill, the term bill of exchange, and the term draft all mean the same thing. So this is a bill of exchange, draft. It's all the same terminology. That's what this thing is that comes in the mail that unconditionally orders you to pay a certain amount by a certain date. Okay. Now, when you start to get into, yeah, go ahead.
Coupons. We get payment coupons in the mail. You know,
that would be this here.
Does it still fall under the same?
The coupon thing, I'm not entirely sure exactly how that all works yet. I believe if you look up the definition of the word coupon, it's an interest payment. So I believe this is the actual bill. And then because this bill is a negotiable instrument, it is a financial instrument, it has intrinsic value of $356.30. This is a debt instrument valued at $356.30, right? So I don't know exactly how the coupon will work like something like this, but this is the coupon part. I'm assuming at this point in my research, this would be the interest payment. And you also got to think too, is there's account information here on the bottom. So it's sort of like, it's a little bit confusing. I'm not totally sure exactly how it all works. I assume this account has $356.30 of value in it because this is basically a registered security by the time they send it to you. And what the person who it's registered to is the person listed at the top of the bill, Glendale, City of Glendale, right? Or City of Glendale Water and Power, right? When you look in UCC 3, that's called the drawer. The drawer is the person who is ordering payment, and the drawee is the person being ordered to pay. So the drawer would be the person whom of which the bill of exchange or draft is registered to. And then in order for it to be registered, it would have to have some kind of an account associated with it. So at this point in time, I'm assuming this account number down here or these numbers down here has to do with some kind of routing and account number. Because when you start getting into UCC 3, what's really interesting is if you go to order, right? The definition of order means a written instrument to pay money signed by the person giving the instruction. The instruction may be addressed to any person, including the person giving the instruction, or to one or more persons jointly or in the alternative, but not in success, blah, blah, blah. Anyways. So an authorization to pay is not an order unless the person authorized to pay is also instructed to pay, which is an important part, right? If it said you could, if you want to pay $356.30, then it wouldn't necessarily be a bill of exchange, okay, or a draft. So the way this works is, and people say the word, oh, it's not signed. Well, it is signed because the definition of signed in another area means any symbol or icon or anything that shows some sort of an acceptance or basically, that you're signing off on this thing or whatever. So the literal The signature on this would be the logo here, or it would be just the name here. Those would both be signatures. So this is signed as per the definition of a signature from. I can show you. I built a whole flowchart on this recently because there was so much confusion on it, even in my own world, right? So I built this flowchart to help everybody out. And you can see here, I added the word signed on here specifically for this issue. It wasn't on the original flowchart. So signed from UCC 1-201 subsection 37 means includes any symbol executed or adopted with present intention to adopt or accept a writing. So if we go back to the draft or bill of exchange, we take a look at it. We can see here that what was the definition again? Any symbol executed or adopted with present intention to adopt or accept a writing. So this would be a signature here, which would be the Glendale, California, and the little bubbles. This logo would be a signature. And then by them simply having this name on here and the fact that they sent it, and there's more information here. There's some kind of little codes here. These could also be account numbers associated with the fact that this is a financial instrument. We have some kind of a barcode. We have another QR code right here, and then another barcode here. So all this information would all be part of the fact that it is in fact signed. And then we have the definition of signature, which is in UCC 3-401 subsection B. A signature may be made manually or by means of a device or machine, and by the use of any name, including a trade or assumed name, or by a word, mark, or symbol executed or adopted by a person with present intention to authenticate a writing. So again, this would be both signed, and then this whole section right here would be the signature. When you start studying all this stuff, it requires you to tear out of a lot of the terms that you've been using your whole life and to sort of reprogram your whole mind, because you think the word bill just means, something you have to pay. And you think the word pay means to send in negotiable instruments, send in Federal Reserve notes, right? Definition of payment was also added to this list because it's an important definition. Payment means the performance of a duty, promise, or obligation, or discharge of a debt or liability by the delivery of money or other value. So the thing is that this document has intrinsic value because it is a negotiable instrument, just like a Federal Reserve note. And when you start getting into the definition of the word cash, in its most basic definition, a bill is cash. So what's happening is they're sending you cash and you're supposed to send it back. That's basically this entire subject in a nutshell, right? Now, the way in which you send it back has to do with the way that you endorse the instrument. So an endorsement is also in UCC Article 3. We talk a lot about that, right? But the flowchart is probably the easiest place to show it to you. You still with me?
Oh yeah, I'm with you.
So we have this is unconditional. So we have the negotiable instruments, UCC 3-104, and then here we have the unconditional order to pay, which in UCC 3 is called a draft, but in a lot of other areas it's called a bill or bill of exchange. So the term bill of exchange and the term draft mean the same thing, okay? So here's different examples: traffic ticket, parking ticket, tax bill, utility bill, credit card bill, court order or judgment, a check. A check's a little different. So by definition, a check, for it to have a check, so a draft does not need to have any banking information on it. So if we go back to this bill of exchange draft, we see all these numbers here. We see this barcode. We see this QR code. We see this barcode. And then we scroll down. We see some stuff here on the right-hand side, GWP, a bunch of numbers and letters and stuff. And then if you scroll down to the coupon, we have another set of barcode. We have another barcode here. We have a bunch of numbers at the bottom. So the thing is that this is probably a check. It's probably two checks. The upper part is a check, and then the lower part is also a check. I'm not 100% sure on that, but that's kind of where the research is at right now. Now, in order for it to, let's say, for example, it didn't have any of these numbers, and it didn't have these barcodes, and it didn't have any possible bank routing or account numbers on it, it wouldn't be a check, it'd be a draft. So a draft is if you removed all this information here, all this information, and all this information, just in case it could possibly be banking information, it's just a draft. When you start adding banking information and routing and account numbers and stuff onto the draft, it becomes both a draft and a check. A draft is the rule book, the monopoly rule book for drafts is UCC Article 3. The monopoly rule book for checks is in UCC Article 4. So when you understand how those two things, but the thing is that this, even though this is a check, it's also a draft. So it would still fall under the rules of a draft. It's just that it also has banking information on it as well. Okay. So the word check and the word draft are two different things. But what we're looking at with a utility bill is we're looking at both. This is a draft and a check. Okay. So when you receive that draft or bill of exchange, you become what's called the holder. And there's a lot of information about this in UCC Article 3, right? And the definition is longer than this. I just try to keep it simple on this flowchart and not get too crazy because the definition is super long and it'll go down, down through all this area, right? So in essence, the holder is the person who's holding the bill. There's a lot more to it, and I'm oversimplifying it, but to keep it really, really simple, that's basically what it is. So for example, an example of this is whenever you get a Federal Reserve note. Whenever you get a Federal Reserve note, you are the holder of that note. And then if you look at UCC 1-309, no, 3-309. Let me see here. This might take me just a moment to find.
While you're finding it, I'll say that the UCC, you keep mentioning, it's the rule book. So I've read Article 3, and it's one of the most confusing rule books ever put together. And some of the definitions of these things, they overlap with their own words. Do you know what I mean?
Yeah, it is. It's really confusing. You have to take your time, and you have to clear up all the definitions of all the legal words, and then you have to kind of piece it all together. I mean, this flow chart is probably the product of a year and a half of focused work to build this flow chart.
Yeah. So no, it's definitely a streamlined version, and I know a lot of people out there appreciate it. Can I ask you this, Brandon? Could we take a step back? I anticipate a large chunk of the viewers of this episode are going to be people familiar with you, people going on YouTube and looking for more of your content like I have. Mm-hmm. And you've got a lot of great resources about the in-depth information we're going over here on the flow chart and negotiable instruments and everything else. But what I haven't heard you talk so much about, a little bit, but not as much, is we'll go back to that first question I asked you, which is why? Why do you do this? What is driving you forward to do this?
Oh, well, I think that people deserve to know, and I want to know. I mean, one of the best ways to learn is to teach. It's a little bit of a goofy, statement to make, because how can you teach something you don't know? It reverses polarity. It's sort of like a battery. It reverses the polarity. So it's sort of like DC power. So you take DC power like a battery, right? When energy in physics flows in one direction for too long, it doesn't self-generate energy. It's just a depleting energy. For example, a battery is DC power, right? What's in your wall is alternating current, AC power. AC power is when the positive and the negative sides flip and the flow of energy goes in one direction and the next, like this all day long. That's what's happening in your wall sockets, right? With a battery, the energy is coming out of the positive side of the battery. It's flowing through the circuits, and then it goes back in on the negative side, and it's a single directional energy, right? So when people say they're, quote, getting burned out on anything in life, it's because what's happening is they're operating in that area of their life using more of a DC mentality. If they use an AC mentality, then they would never get burned out. It's physically impossible to get burned out. It's just physics, right? Physics operate in social environments, etc. That's why marriages break up and people get bored in marriages. That's why a lot of things happen, because the person is flowing energy DC in a certain direction for too long a period without without flipping into more of an AC energy. So if you want to have infinite energy in your life, you just simply follow the rules of physics, and you operate in every area of your life using more of an AC current style of living. So my version of doing an AC for learning is to teach it. You learn it, you teach it. You learn it, you show it. You learn it, here's the breakthroughs. You learn it, here's what I'm figuring out right now. You learn it, there's some things that need to change. We got to change these things. Like right now, we're going through a lot of changes. So it's the AC current is basically what I'm doing. So I try to mark everything very, very carefully, because it's difficult to teach things that you don't know, but I'm trying to learn and nobody else seems to know. So I don't know what else to do. Well, it's like, what am I supposed to do? You know what I mean? And I'll go through something and then I'll be like, oh, this is it. I got it. And then I'll teach that for a while. And then, like right now, we're going through a huge period where there's a bunch of stuff that we had a lot of success with, but it's just totally not correct. And I'm just kind of throwing it all out. So there's also a lot of that too. So it's basically, that's one of the reasons why it's all free too. I really enjoy the fact that I don't have to be tied down to any sort of, like I already feel bad enough as it is that I'm about ready to be releasing a lot of changes. If I charge people, I think it'd just be a lot more difficult for me, because I'd be like, well, shit, what do I do about all the people that paid, But, like with the people at the law firm, like the clients that I have at the law firm, I make it very, very clear. And they know, this is all kind of like fringe research work. This is not anything that is nailed down. I mean, there's certain areas that really are nailed down, and there's certain areas that I thought were nailed down pretty well, and then come to find out not so much. But we have things, I would say, not to be egotistical, but I would say we have things more nailed down than anything else you're going to find anywhere else on the internet. That I could tell you, like, for sure. Might sound a little egotistical, but I just know that for a fact, because we take information from everywhere. So we're like a nexus. We're like a hub, right? So we take information from literally everywhere and bring it into the center, and then try to piece it into the puzzle somehow, right? So, yeah, I guess that's kind of it. So the whole UCC3 thing had some changes that happened recently. Like the overall situation is still the same, but there was a couple of adjustments that had to be made inside some of the processes we were doing. But like 95% of everything is still the same. So we're still very grounded, right? With some of the other stuff, I have this other flow chart that I'm working on right now, having to do with like the difference between the commercial world and the non-commercial world, which is called the private and the public. And I have a whole flow chart on that, which I can briefly show you. This one kind of changed a lot of things, and I'm kind of still even in the process of not even knowing exactly what all is going to change, but there's going to be a lot that's going to be changing. Some very, very basic aspects of some of the stuff that we've been doing for a long time is actually going to be changing because of this flowchart. So, this would take me a while to kind of go through all this, and it's kind of a work in progress, but this just kind of gives you a basic overview of what I'm doing. You have the private, you have the public, right, which is commercial and non-commercial. And then you have all the different elements, and then case law and all the legal stuff associated with how that all works. And then what kind of legal entities are located in the private and what kind of legal entities are located in the public in terms of commerce and nonprofit. You'll see in the IRS, you'll see all over the government everywhere, nonprofit and profit are two totally different categories. Well, there's a lot. That's a much deeper rabbit hole than anybody really realizes. Profit and nonprofit is literally the positive and negative sides of the entire battery of our entire existence. And when you start to understand the flow between the two sides of the battery, you can actually again create sort of like an AC current. The whole point of all this research is to create an AC current between the public and the private, right? So you go back and forth and back and forth and back and forth. You already are kind of doing it in your life, you just don't know it. So what we're trying to do is we're trying to become more aware of what it is that we're actually doing, right? And that's kind of the point of this whole flow chart and a lot of my research, right? This flow chart is sort of like a culmination of probably 2.5, 3 years of research, all put together into one chart. So it's pretty intense. I probably won't get into this one on the show, but ideally, something like this would be simplified so much that you could get into it on a show, you know. So that's kind of like the future, hopefully, of this, right? But I mean, really, the ultimate simplicity of why I do it is just I find it fascinating. I'm very curious, and everybody else is too. So you know, just sharing what I find as I find it, and then I get a lot of support and information and stuff like that. So my fans basically fuel my research. If you really want to get, I'm basically a full-time researcher now. I live sort of like my dream life. And the reason why that occurs is because people support me, which the first year of me doing this, I had zero support. In fact, everybody in my life exited as though I was a burning house fire. They thought I was going to be, you know,
fringe ideas, man. There's people, I've mentioned this to people in my own life, and you do not get support.
Yeah, so the first year was very lonely, very lonely, very sad, very depressing. But then as I continued, probably about after the first year or so, we started to see a lot of people coming, and then throughout that second year, you know, massive growth. And then now we probably have, I think in all three websites combined, onestupidfuck.com, the Nation of the Amnesty Coalition.org, and then Williams and Williams Law Firm.com. I would say we're probably around 100,000 visits a month, something like that.
Very nice. The idea is definitely growing, and it. I don't know. I mean, what's the end game with all this? You know, I've thought about that myself. Like, okay, let's
the
connect
end game,
the dots, and more.
The end game is the elimination of the 14th Amendment. The 14th Amendment was illegally ratified, which is said by Congress in the Congressional Record of 1967. This isn't even my words. This is actually Congress's words. The states, there was a handful of states that were actually under duress. They were threatened that if they didn't accept the 14th Amendment, they wouldn't be accepted into the Union. And it's part of the most basic aspects of contract law that a contract that is signed under duress or menace is not a legal contract. So the final 5 or 6 states that supposedly signed the 14th Amendment, they didn't legally ratify the amendment, and the amendment was actually shy several states, which is actually why they threatened those states, because they knew it wasn't going to work unless they threatened them. So the 14th Amendment is what created the U.S. citizen category. Mm-hmm. So basically, essentially, as far as I'm concerned, there is no such thing as a U.S. citizen.
Right. So
when you start going down that rabbit hole, it's quite an extensive rabbit hole, because basically everything happened after that point. So there was an entirely second country set up. So there's multiple United States, and you can even see that on my flowchart. I'm starting to build out literally case law on this because I'm trying to figure out how I can get these ideas into the mainstream court system, which is obviously a massive feat, but I'm building it all out, right? So if you go to my newer one here, you have here in important note number 2, you have a quote from the Supreme Court ruling in 1945, Hoover and Allison Company versus Evatt, 324 U.S. 652. The term United States may be used in any one of several senses. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. It may designate the territory over which the sovereignty of the United States extends, or it may be the collective name of the states which are united by and under the Constitution. So for example, I'm suing the United States Small Business Administration, and as usual, there's a lot of confusion. The defense attorney believes that they have sovereign immunity. Well, the defense attorney doesn't even know the definition of, doesn't even know the party, which United States, so he's talking about all this stuff and he has no idea which party is the actual party in the lawsuit, right? So I'm about ready to do a response and I have to clear all that up in the court, right? And I was looking for a way to do that and I found this, right? And then we also have here, there was a footnote in this case. For anyone interested in this, I recently learned this, which is hilarious. It's so fucking simple. If you go to Google Scholar and you click on here, it says case law, you can pick which courts you want to go to. So for example, if you just want to see Supreme Court only, U.S. Supreme Court, you can do that. And then you can type in anything in here. You could type in eviction, say you have an eviction case. And you want to learn about what they're saying in an eviction case. You can click on this first case here. This comes from 1970. You can type in find feature and you can type in eviction and you see there's 32 mentions and you can go through this and you can just read every single spot where the word eviction comes up, right? And you can do this, for example, if you have a case in California where you're being evicted, then what you do is you go to Google Scholar and you go to case law and you go to select courts and you're going to go down to, if they're suing you in a state court, let's say they're suing you in the Central District of California, which is the LA area, right? You'd go down here to California. You would find the Supreme Court would be good. Appellate would be good. And then we're going to go to done and type in eviction. And then we're going to type in, this would be good. So now we can go down here and we can just look at all the various things that are being said regarding eviction in various cases in this district. So the Central District would be the most ideal place to look. Let's see what we have here. This is the Supreme Court. This is fantastic. So if you wanted just Supreme Court only, you would just go back to select courts, go down to where we selected the appeals court. We would just unselect that, only have the Supreme Court, hit done. Now we have only Supreme Court cases, and then we can list. So let's say we go into this one here, and we go to eviction, and we find something we really want to use in a case that maybe we're the defendant. Then all you do is you would just say, you would just copy this and then copy this. And then boom, you'd paste it into your response or your lawsuit or bring it up during a hearing. And that's basically what people are doing. A lot of people are using AI and stuff now, which I haven't really, I think this is a much safer bet than using AI. AI is pretty hit or miss. But anyways, so if you look here on this court case from 1945, if there was a footnote at the end of this quote, and this footnote has a bunch of these other things here. So you could go and look up all these other things too, and you can get a whole bunch of additional case law as regards to this whole situation. And what's funny is even the DOJ attorneys don't know this stuff. They don't know that the term United States has a bunch of different meanings, right? Nobody does. So you got these DOJ attorneys, like the one in my case, who's been a bar card holder for 3 years. He's defending the United States, and he doesn't even know what the definition of United States means. So it's hilarious. When you start getting into this stuff, it's actually really funny because these guys really don't have a clue. They absolutely don't have a clue, right? Now, my issue is you say stuff, but then they're just like, oh, you're a sovereign citizen. So the problem that I'm running into that I'm trying to figure out is how do I build out all the case law and find all the case law and find all the definitions and everything and build it all out like structurally all through case law rather than just by saying things, right? So that's sort of what I'm doing now. That's kind of where the research is heading. That's where the lawsuits are heading. So, I just started filing lawsuits this year. So we're in appeals. We're in a couple of appeals courts. And then we've also done some other cases and stuff. So we're just having some fun. I filed my first state case, but it got remanded to federal court. So I haven't really had a chance to really play too much in the state courts, which that's going to change here real soon. We're going to have a ton
Brandon,
of
how do you
state
get
cases.
over the fear of litigation? You've actually been inside a courtroom, right?
No.
Have you gotten to that stage yet?
No.
This has all happened.
You'd be surprised how little time. I mean, I would imagine you could do a whole court case and never ever go end up in the courtroom at all.
Really?
Yeah. I just you'd be surprised depending on so it depends on many factors. It depends on what it is that you're litigating. It depends on because the only reason why you would need a hearing is because you need a hearing. If everything's pretty clear in the pleadings and the filings, that they'll cancel the hearing, and you can cancel the hearing too. If I don't want a hearing and the defense doesn't want a hearing and I have nothing else to say and the defense has nothing else to say, there is no hearing.
Okay.
Now, if I request a hearing, I can request an informal or formal hearing. You would literally do that in writing. You would request a hearing, right? So the thing is that the court is sort of like a car, and what's happening is the plaintiff's getting in the car and then driving it around, and then they get out, and then the defendant is getting in the car and driving it around. Essentially, that's kind of how it works. It's not really like what people think. That's why it's called a motion. You've heard that term before, motion, right? You're moving the court. So basically, a court is basically like a football field, right? You have pretrial, you have discovery, you have all these various aspects that as the ball moves down the field, there's different things that are going to happen, right? Motion just means to either move the ball off the field over here into some little side pocket or to move the ball down the field and do the next thing in the rule book, right? So in its most basic essence, what's happening is the plaintiff is trying to motion that ball down the court, and the defendant is trying to stop that motion from taking place. It's really just a football game, if you think about it. And then there's various rules as to how can the ball get moved. And if the ball gets moved, it's sort of like unnecessary roughness or out of bounds. If you move the ball in a way that's not acceptable as per the rules, then you get a 5-yard penalty or whatever. It's the same idea, really. I mean, honestly. And when you start to realize that, and you start to realize the way that it works and the way that the game is played, I mean, yeah, it's kind of scary, but I mean, football is kind of scary too. People get hurt real bad all the time. I mean, it's the same thing.
Yeah, I mean, there's no lying that it's scary. The idea, because I think we're probably programmed to be afraid of it, right? It is just
we're
baked
programmed
into
to
us.
we're programmed to be afraid of the unknown, and there's nothing more unknown than the law. Even the people that are in there don't know what they're doing. So how are we supposed to know? That's the problem.
Yeah. Now, before doing any of this research, I wouldn't have agreed with you, but I do, because who goes and reads the UCC? Not very many people, very few indeed, man. So
I'm trying to make it fun and simple, and because once you crack the UCC, it's infinite money. And when I say infinite money, I mean it's a joke. It's not money. It's currency. But we say infinite money, but it's really infinite currency, right? So, when I say infinite currency, I mean literally infinite currency. I mean If you want to cook up $400 trillion this afternoon, you can do it.
Yeah, no, I mean, I'm starting to understand that, but let me go back to that question. We talked a little bit about the end game with the 14th Amendment and citizenship, but what about with infinite money? I mean, like once this is cracked
So
and you
once
can
the
whip up
14th
400
Amendment
trillion
is
dollars,
torn, then the infinite currency thing in the UCC goes away. There won't be that game won't exist anymore. Not in this country.
I don't. Do you think the country can stay standing through this? I mean, no, because literally, to remove the 14th Amendment, you'd have to remove the federal government, wouldn't you?
There'd be no federal government. There'd be no District of Columbia. There'd be no FBI, no CIA, no FDA. There'd be no Federal Reserve. There'd be no Federal Reserve notes. We would go back to what's called, if you look in the 1800s and you start studying a lot of case law involving negotiable instruments, you can go to Google Scholar and you can type in negotiable instruments or type in endorsement, INDORSEMENT, or other terminology associated with how negotiable instruments work. And you'll see a lot of those court cases are from the 1800s. They use the term specie. So specie is these bad boys right here, gold and silver coins, which is the actual real money, right? So negotiable instruments and then specie, right? So specie is what we would go back to, right? And then people say, oh, well, we're so used to being able to order on Amazon and do all these things. If we go to a specie, back to a specie monetary system, how would that work with our new digital world? And that's a real issue that's going to have to get solved. There are gold-backed crypto coins and stuff like that. So the question is it going to be government regulated? If you take away the 14th Amendment, specie can't really be government regulated. The coins can be regulated, but the Bitcoin and all that kind of stuff really wouldn't fall under any ability for the governments to regulate them, right? Because if you look at, for example, in California, there's two different versions of California. There's state of California with a lowercase s, and there's state of California with an uppercase s. And I've recently found all of the references and stuff to prove this. I had this as a theory, but now I can prove it. And there's two different constitutions. There's one for lowercase s, state of California, which is from 1949. And if you look inside of the 1949 Constitution for state of California, lowercase s, it says right in there, I think under Article 3 or Article 4, that bills of exchange, promissory notes, and other negotiable instruments cannot be exchanged in the society as currency. So once the 14th Amendment is gone, then the currency system is also going to be gone as well. Every state's different, but the thing is that the entire commercial system that holds Federal Reserve notes in place would disappear. And then in certain states like California, it's already illegal to have something like Federal Reserve notes acting as currency. So naturally in California, automatically all currencies would instantaneously be void, essentially, at that point.
Interesting. Okay, so I personally don't believe that if we get to the point where you crack this wide open, or when, I should say when, I don't know. I don't think ordering off Amazon is going to be top of list worries.
Well, the cool thing is that it's a small problem, because the thing is that if you think about it, if you look at the value of our dollar since 1913, people have seen those graphs. You're going to be able to, in a specie, if we go back to a specie monetary system, you're going to be able to work at McDonald's flipping burgers, and you're going to have like a freaking 3,000 square foot house, 7 kids, 6 brand new cars, 4 motorcycles, 2 boats, and a maid and a gardener. Maybe not like in the Hollywood Hills, but like, in Iowa or Kansas or whatever, you'd probably be able to borderline sustain a lifestyle like that at the blue collar level. Maybe not flipping burgers, but just a teeny bit above that. I mean, flipping burgers, you could have a car, a motorcycle, and a nice apartment easily, single man's life without question, right? But I would say you could probably be married with a couple kids and flip burgers and you'd still be okay. So the problem in our society is inflationary. It's inflationary, and it's a problem because the monetary supply has not been tied to specie, right? You can actually go onto a website called I'll show it to you. It's called WTF happened in 1971. WTF happened in 1971.com. And this is basically a bunch of graphs, and it shows you that 1971 was the exact point when the country started to go to shit at a very rapid pace, right? And 1971 was also the same year that the final killing blow that attached Federal Reserve notes to gold. And that was the year when our currency went onto a full-blown fiat. People say the word fiat. So in 1913, you have the introduction of the Federal Reserve Act, which basically made so as far as I can tell from my research, Federal Reserve notes were basically just like an internal private currency for the District of Columbia. So the Federal Reserve Act then made it more of a public usage. And then up until 1933, there was all sorts of things going on. There was gold certificates, which were paper money that you could exchange straight for silver. There was gold certificates. I have some over here on the counter, but you can type in gold certificate, right? And you can see photos of what those used to look like. Let me see if I can find a photo for you.
Gold certificate, very interesting. So I think the monetary system we're currently on is a fractional reserve banking system. Have you ever heard of that before?
It's not really what it is. So basically between 1913 and 1933, we had gold coins, we had silver certificates and silver and Federal Reserve notes and other bank notes. So 1933, we have the Emergency Banking Act, right? And an exact direct quote from the Emergency Banking Act I already have for you here on my flowchart. Go down to the bottom right. So this is from the House Congressional Record of 1933. They say, under the new law, the money is issued to the banks in return for government obligations, bills of exchange, drafts, notes, trade acceptances, and bankers' acceptances. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. And then we go to 18 U.S.C. 8, and we see that in action today in 2024. 18 U.S.C. 8 is called Obligations or Other Securities of the United States Defined. The term obligation or other security of the United States includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes. Here's your word, coupons. United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposit, bills, checks, drafts. So basically everything is essentially not really yours. It's actually the government's. And that includes assets. So you think you own your car. If your car has your name on it in all capital letters, you don't own your car. Your car is owned by the government. But on the flip side, all your debts are also owned by the government. So you don't have any debts and you don't have any assets. You don't have anything. Everything you think you have, whether it's a debt or an asset, is actually the United States, right? And that happened during the Emergency Banking Act of 1933. And it says, literally says right on the dang thing, it will represent a mortgage on all the homes and other property of all the people in the nation.
Very interesting.
So a certificate of title that you get from the DMV lists your name in all capital letters as the registered owner. What is a registered owner? Registered owner, the Black's Law was down for a while. They just came back up again, so I can actually show it to you straight from the Black's Law website right here. Owner whose name is recorded in a security issuer's registrars as the security's owner and is entitled to receive dividend or interest and principal payouts. So when your name is listed as on there, it means that the state, which is the United States, it's a state of California is a sub corporation for United States. So state of California owns the car, and you just have basically the right to take the profits of using the car in a commercial capacity. That's what the term registered owner means. So if you have a certificate of title, that means that you have the right to use your car commercially, and then the profits that come from that activity are yours. But the actual asset and debts associated with operating that vehicle as in a commercial capacity would actually be the government's. And there's two ways you can use that information. Way number one is you can stop fixing it and stop paying the bill on it, because the thing is, you go to the government or you go to the state and you say, hey, this is actually your guys' bills. This is actually your guys' asset. You need to pay to fix it. You need to pay for the registration fees. You need to pay for the gas for it. You guys are actually the ones supposed to be paying for all this stuff, not me, right? That's one way you can do it. The other way you can do it is if you get rid of the certificate of title completely, you become the absolute owner of it, and then now it's not a asset or debt of the United States. Now at that point, it really is, you actually do own it at that point. You wouldn't get it registered. You wouldn't get license plates. You wouldn't have a driver's license. That's actually the difference between, like we were already talking before, you have the public and the private. So if you have a certificate of title, you're operating that vehicle in the public. You're operating that vehicle as a commercially. Everything has to be commercial, and the reason why is because of the Commerce Clause in the Constitution, right? So the Commerce Clause, I have it right here. The Commerce Clause, the Constitution, quote, gives Congress broad power to regulate interstate commerce and restrict states from impairing interstate commerce, right? This is what gives the United States what is called plenary power. And here is a quote from Cornell Law regarding plenary power. This term is frequently used to describe the commercial power of Congress. Under the Commercial Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce, right? Now, the part that this gets interesting is they have power to regulate, and they also are able to restrict states from impairing interstate commerce. And you see that echoed at 15 U.S.C. 1, which it makes it illegal to restrain trade, right? Every contract, combination in the form of trust or otherwise, or conspiracy in the restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. So you ask yourself, well, hold on a second. How can prostitution be illegal? How can drug trafficking be illegal? How can these things be illegal? And the thing is, they aren't. If you were to bring all this up and you knew this information and you were to defend yourself as regards to some sort of a commercial activity that was occurring in the state, they can regulate it, but they can't restrict it. So the thing is that everything is essentially a commercial crime, but the thing is that commercial crime is an oxymoron, because there is no such thing as a commercial crime. So the whole thing is a bit of a joke when you start to really go down these rabbit holes and look. But the thing is that you don't own your car, you don't own your home. If you have a title for your home, there's something called an allodial title, or what's called a fee simple title. Fee simple title. This allodial is the kind of title.
I've asked a few real estate entrepreneurs and agents about that. They all say it's hoaxes.
Yeah, so you wouldn't use the term allodial. They think that's a sovereign citizen thing. You would use the terms fee simple. Fee simple is the actual technical term. So if you say allodial, they're going to call you a sovereign citizen. If you say fee simple, I get all sorts of different reactions. Fee simple is the term I would use. So fee simple basically is the same thing as saying allodial. You can actually get a fee simple title. If you have a fee simple title, then the assets and the debts associated with that property are now yours. If you have a normal type of title or quitclaim deed and you don't have a fee simple title, then the debts and the asset are both obligations or other securities of the United States, which again is echoed back at what Congress was telling us. We have it will represent a mortgage on all the homes and other property of all the people in the nation. People have heard the term the full faith and credit of the United States. People have used that term, and you've heard that term a lot, especially in congressional hearings and stuff like that. This is what they're referring to, because the thing is that when the financial when the financial specie was removed from the currency supply in 1933, it used to be a specie-backed currency, and then in 1933 it converted from a specie-backed currency into a currency backed by the quote full faith and credit of the United States. Full faith and credit of the. So this is what backs Federal Reserve notes, right? And you can read what that means, and you can even type in full faith and credit of the United States into various case law, and you can read. I'm kind of doing a lot of research about that right now myself. So full faith and credit, what does that mean? It means basically it represents a mortgage on all the homes and other property of all the people in the nation. But then it got a lot more dark because right after 1933, you have what? You have the Social Security Act, 1935, right? And if we go into the Social Security Act, this is quite terrifying. This is for all the conspiracy theory people really get excited about this. If we go to 20 CFR 422, CFR 422 dot, what is it, 102? What was it? Let me see here. 422.
It's about bonds on everyone's life.
104, right? This is pretty terrifying. So who can be assigned a Social Security number? So again, 1933, Emergency Banking Act, which is what you just read. So this congressional hearing where they're talking about how the new money will represent a mortgage on all the homes and other property of all the people in the nation. This was probably like July of 33. And then bang, what do we have like less than 2 years later? The Social Security Act. So who can be assigned a Social Security number? If you go down, one thing I like about Cornell is it connects special definitions into the various statutes, so you can click on them. If you notice, it's kind of terrifying. The word "you" has a linkable, clickable link, right? We can assign you a Social Security number if you meet the evidence in Section 422.107. So what is the definition of the word "you"? The word "you" comes from 20 CFR Section 422.402. You means an individual who owes a debt to the United States within the scope of this subpart. So you means debtor.
How can we be a debtor to the United States when all debts are the obligation of the United States?
Well, so basically the way that it works is the Social Security Act basically merged all of us into United States. So essentially the way they look at it is United States and you is the same person, essentially. The full faith and credit of the United States. Again, what does it say? It will represent a mortgage on all the homes and other property of all the people in the nation. So the way that it really works is everyone doesn't realize it, but basically everyone has the choice to have a fee simple title. Everyone has the choice to not register their vehicle with the state. So because in contract law, you can't have a forced contract. That's illegal before the 14th Amendment, and it's also illegal after the 14th Amendment, because even the whole basis of the 14th Amendment was slavery and involuntary servitude and stuff. So everything is voluntary. There is no involuntary anything, right? So the way that they look at it is you are essentially donating the car or the property to the United States to be used as part of the full faith and credit of the United States, which backs the fiat dollar. And the idea that you can simply exit that if you so choose is completely true. It's just nobody knows it. The door is wide open. It's just no one's ever seen the door or knew it was there. So that's basically the whole thing in a nutshell, right? So the only way that they can use your assets or property as part of the full faith and credit of the United States is under the Commerce Clause. They have to turn it into some sort of a commercial activity. So that's what they did. They listed you as the registered owner. So the registered owner is the person who gets the profits from using that home or whatever. Like, for example, property taxes. Property taxes should be sent to the state or sent to the Treasury, because the thing is that property taxes are a debt, and that debt is an obligation or other security of the United States. Now, if you don't have a title under the state and you have a fee simple title, you can't send the bill to the Treasury. So if you have if your property is registered under the state, it would be in the public as a commercial property that is a mortgaged property on the homes and other property of all the people in the nation, and all of the assets and debts associated with that property would be obligations or other securities of the United States under 18 U.S.C. 8. And then you would be entitled to use that property commercially, and then you would be entitled to be the beneficial owner of the profits of that property. If you get a fee simple title, you're over here now in the private. Now, the fee simple title, what that's going to do is that's going to make it to where the asset is yours, but the liabilities are now also yours as well. The issue is that we're sort of riding right in the middle. That's the problem. So all of the assets the government claims, and then all of the liabilities it claims you also have, which is not true. You have either all the assets and all the power and all the liability on the private side, or you have none of that on the public side. So you wouldn't be paying any sort of fees. You wouldn't be paying any sort of upkeep on the property. In a way, you could almost say operating in the public is actually more financially sound, because the thing is that you would be entitled to all of the profits. So basically, if you have a home in the public, and you have like basically everybody in the country has a home in the public, right? The way that it actually works is you don't have to pay for anything. You can use it as a commercial activity. You can run a business out of your home. You're entitled to all of the profits free and clear, and you don't have to pay any of the expenses associated with that property, right? So in a sense, you could operate in the public, and you can operate it in a really beautiful way, and you can have tons of cash, and you can operate your property as some sort of like a commercial business activity. And then anytime you get any bills or the plumber has to come or anything else, you would just send those bills to the Treasury. And if the Treasury doesn't pay for it, you would sue the Treasury. Because the thing is, the Treasury is the people who are supposed to be paying these things under 18 U.S.C. 8 obligations or other securities of the United States. Or if you would rather have all of the asset to yourself, and you'd rather do whatever you want with your property, and you'd rather also incur all of the liabilities associated with your property, you would move that property into the private by retitling it on as a fee simple title.
Very interesting.
So people think I'm anti-government. I'm not anti-government at all, because the thing is that you can operate your property, your car or your whatever, in the public, and you can continue to operate it as you are, and you don't have to pay any of the upkeep fees. You don't need to pay any taxes. You don't need to pay any of that shit. You could literally send a change of address form to the IRS and to the state, the franchise tax board in California. You can send a change of address to, I can show you this too. So for example, let's say you wanted to do a change of address with the IRS, right? This is actually what I'm developing right now. I mean, it's pretty much already done. I just sent mine in, but I haven't shown anyone this yet. So if you go to let's see here. We're going to go to my flow chart, right? If you go to, let me see here. We're going to go to the IRM section 3.8.45.5.10.1. So IRM 3.8.45. What was it again? Let's see here. 0.45.5.10.1. 0.5.10.1. Okay. It's just 5.10.1. 5.10.1. There we go. So here we go. If a bill of exchange or registered bill of exchange is received from a taxpayer authorizing the campus to settle their account using Fedwire, send everything received to the following address. So what I did was, and basically what this means in English is if you receive an unconditional order to pay from the IRS and you realize that it's an obligation or other security of the United States, and you would like to have the United States handle it for you as an obligation or other security of the United States, send it to this address. So what I thought about was if you have the 8822B form, which is the change of address or responsible party for the IRS, you would literally just, your name in all capital letters is a business. It's a sole proprietorship. So you would just type in your name as the business. You would do, change of business, change of this, change of that, right? You would type in your social security number here, right? Old mailing address, new mailing address, 1500 Pennsylvania Avenue, room 3413, Washington, D.C. 20220. Washington, D.C.
So you're just sending them the bill.
Well, no, this gets better. You can send them the bill. What you're doing is you're permanently sending them the bill when you do an 8822B, right? So the new responsible party's name is going to be Department of the Treasury, Office of Executive Secretary. Boom. I don't know their EIN number, so don't know, I guess. Not sure would be, new business location. So you can change the responsible party and you can also change the business location, right? So if you wanted to change the business location, like for example, I have a PO box. So what I do is I did like this, Glendale, California, 91209. That was the old business address. And then the new business address would be 123 Purple Monkey Lane. And then below that, you have foreign country name. It's the Nation of the Amnesty Coalition. You would write in your social security number here with a pen because they don't let you, because the dash counts as like a letter, and you'll see it'll cut off 4, 5, 6, 7, 8, and then you won't let you put the final number in because that second dash, an EIN number only has one dash. A social security number has 2 dashes. So you have to manually handwrite the social security number in here, right? A social security number is just an EIN number for a sole proprietorship. And I get into all that in the flow chart, right? So the social security number is it's just your name is just a business that is just your name. That's all it is. It's a business, right? Type in what IRS, what is a sole proprietorship? And they tell you straight up. A sole proprietor is someone who owns an unincorporated business by themselves. So they assume you are a business. Your name is a business. And that business has an EIN number. The EIN number is called a social security number. So you would just type in, you can even see it on an SS4 form. You can see when you're an application for employer identification number, if you go down to type of entity, it says sole proprietor, and then it says SSN. The Social Security number is pointing towards a sole proprietorship. You are the owner of that sole proprietorship. So the Social Security number is an EIN number for the sole proprietorship of which you are the owner. And, for people who are used to this kind of information, we can go to the Internal Revenue Code, a tax code, and we can look at 26 USC 7701, which is the primary definition section for the entire tax code. And we can look at subsection A1, the definition of the word person. The term person shall be construed to mean and include an individual, a trust, estate, partnership, association, company, or corporation. The term individual means individual proprietorship. The term individual proprietorship means sole proprietorship.
Wow.
So when you fill out your 8822B, what you're doing is you're changing the address of the sole proprietorship, and you're changing the responsible party of the sole proprietorship under 18 USC 8, obligations or other securities of the United States. And then I have like a really simple cover letter that basically just says, I hereby permanently authorize. You just use that same terminology. I hereby permanently authorize the campus to settle the account of the taxpayer through Fedwire. That's all it is. The attached 8822B is a permanent authorization for the campus to settle the account of the taxpayer called Brandon Joe Williams in all caps using Fedwire permanently.
You've previously said the IRS is pretty easy to deal with on these things, so you just expect them to do it.
Well, they'll do it because it's part of their Internal Revenue Manual, and it's part of the USC under 18 USC 8. So Brandon Joe Williams in all caps is the person that is behind the full faith and credit of the United States. So whenever you put your name on anything, they're assuming you mean the sole proprietorship. That's why your name's in all caps on all your stuff. That's why the registered owner is listed in all caps, because they're assuming you're talking about the sole proprietorship.
Yep. No, I'm following you. You've also said, I heard you say once in a video, that it's crazy to think that any remedy or relief will come through mail and litigation is required. So specifically with IRS, are you expecting to get into litigation about this realistically? Or are they just going to...
It's funny because the IRS is probably the only organization that I haven't sued, or I'm not planning to either. I always joke they're pretty much the only organization that actually performs. Try to pull some of this shit with the Franchise Tax Board in California, you won't get anywhere. You won't get 1 yard down the fucking football field, my friend. You have to sue the FTB, right? So, suing the FPTB is how you force them to follow the law.
Okay.
With the IRS, you don't necessarily need to. But like, for example, the county is the people who are going to be issuing you your property tax bill, right? I guarantee you, when you write up your cover letter and you endorse the bill that they send you and you send it back to them, authorizing them to settle the debt on Fedwire or FedNow or send it to the Treasury, you can also instruct the county to send everything to the Treasury. And the way that you would do that is you would endorse the bill, what's called payable to the bearer. So the same thing that they have on the Federal Reserve notes and the same thing they have on the old negotiable instruments, this is payable to bearer on demand. You can write that on the face of the property tax bill, and then you put a cover letter, and it would say, I have endorsed the unconditional order to pay, payable to the bearer, and I hereby release this instrument for you to settle using Fedwire, FedNow, or to deal with the Treasury and to get the Treasury to pay this. And another thing you can do, which is really fascinating too, when it comes to endorsing bills and unconditional orders to pay, I'll show this one to you, right, is you can also write what's called without recourse. So
without recourse, that silver bullet. Brandon, we've got about, I think, 10 minutes left here. So let's cover this. And I have one more final question that I want to cover with you.
Sure. So if you write, let's say, for example, the cover letter, and then you attach the bill, and on the bill you write pay to the order of bearer, and then you sign it by, and then you sign it, and then above that you also write without recourse. Without recourse means that you no longer have any, you no longer need, you're not liable for repayment. So basically, writing without recourse is what's called a qualified endorsement, and it's part of the endorsing process of when you're writing things on the unconditional order to pay. So giving them instructions and then sending back the bill without recourse means I've made this bill payable to where you guys can put it on Fedwire, which is a whole other subject. We're not going to get into that. You can put it on Fedwire, or you can send it to the Treasury and have them handle it. But I no longer have any responsibility over paying this bill, and you can't hold me liable anymore of paying this bill. That's what without recourse means. So if you send it back without recourse and they don't perform, and then they come after you because you put without recourse on it, they can't do anything because you've already said, I don't have any liability over this anymore. I don't have any liability on performing on this or paying this at all. So what you're doing is you're basically shifting the liability back to the county legally.
Yes, but the county's not gonna know what you're talking about. They're
So
gonna
then
suck.
at that point, if you look at UCC3, the way the laws work is once you send it back, they have two choices and only two choices. They can either they can dishonor the instrument, but there's rules on how they can and can't, and they never follow the rules, so they can't do it that way, or they have to perform. So what they do is they ignore it, or they say some dumb bullshit that's not included in the rules of dishonor, which is 3-502. And then at that point, boom, you just sue, because the thing is that they're not playing the game according to the rules, and you sue them because they're not playing the game according to the rules. And the best areas to sue them under is UCC 3-311 and UCC 3-603B, which states that basically a lot of this information, once they receive the payment, they have to perform on it unless it's dishonored. So they didn't dishonor it, they didn't perform, so now you can sue them for breach of contract.
Okay. Speaking of suing, breach of contract, all this stuff. About 2 months ago, I acquired a vehicle from a dealership and created a promissory note with a financial institution. And I had left a blank endorsement on that promissory note. Mm-hmm. At the time, I was ignorant. So since then, that was probably about 3 months ago. Since then, I was sent a coupon, right? I was sent a order to pay, and I endorsed the instrument, made it payable to my all capitals name, the account holder, sent that in, no response. Of course, right? You can't expect to get a response. So I sent it in again, this time via certified mail, and I confirmed they got it. And now I'm at a point where I think litigation is the next move. It's either that or they're gonna come take the car.
Yeah, and they play dumb a lot of times too. Like, for example, everything you send. So if you're printing, this is the way I think about it, right? If you're printing a bill off of like an online login and it's like really easy for you to get another one whenever you want, I would send those certified mail. But like, for example, I have originals here. So I try to get as many originals as I can. Originals meaning like they send me the bill and it's like the original folded bill that I opened and got, right? If I can get originals, then what I do is I actually endorse those, scan them into the computer so I have a record, and then I send them registered mail. Registered mail is when you're sending in like negotiable instruments that are a little bit more difficult to replace. Like Federal Reserve notes really should be sent registered mail if you're going to be sending them to anybody, right? So if the bill's original, I send registered mail, and then you want to have a little cover sheet, right? So for example, I started doing a lot of case law research of a lot of old cases where they did do exactly what we're doing, and they forced them to perform on it, right? And one of the things I keep seeing in a lot of the court cases is that there had to have been some sort of clear cover letter involving like intent, like what you're trying to do, like settle the full account or whatever. So that's something new that we're starting to implement into a lot of this, is just a simple cover letter. And the cover letter that I'm having people send out a lot of times, which I haven't released a lot of this yet because it's like I'm doing a lot of testing right now, is just very simple. It's like this, the enclosed bill of exchange / draft has been endorsed and tendered back to whoever, the person entitled to enforce the instrument, which is the terminology from UCC3. And then the next line would be, please perform on this instrument in accordance with 3-311 and 3-603 subsection B. If you have any questions, concerns, call me here, text me here, whatever, right? So you're saying that basically paid in full is also part of like an endorsement that we don't really use that much, but you can use that terminology on the cover letter. Paid. This obligation is now paid in full. You can even talk a little bit about the endorsements and stuff, but we're trying to keep it really, really short. And then you would attach that to the bill. And then if it's an original, you send it registered mail. And if it's easy to replace, you would send it certified mail. You want to send everything and make them sign for it. You always want proof that they got it, right? But let's say, for example, you sue them and they play dumb, which, God, they love to do that. That's all. They do that shit all day long. That's pretty much all they do. I wasn't expecting that. So they play down. They say, "Oh, we didn't get it. We did." So what you're going to do is, in the court case, you're going to be like, "Okay, fine." So like, but now the whole point of suing someone is like, now like they have to talk to you, they have to communicate, they have to. You're basically forcing them to basically have that alternating current, that back and forth that you can't get through the mail. You can't get it over the phone. They treat you like shit. They ignore you. They call you a sovereign citizen. When you sue them, what you're doing is you're basically forcing them into a conversation. Now we have a conversation. Now it's like, oh, well, we never got it. Okay, great. So I'm going to give you another one now, and then you're going to receive it, and then you're going to process it as a payment or dishonor it as per the rules of dishonor from UCC 3-502, right? You see? So it's sort of like now you're actually in a conversation, and now you're going to, if you have to give them another one or whatever, or you say, hey, I have proof that you got the first one, but I'm here on good faith. If I give you another one, will you process it now? Oh, well, you see, like you now you're not any longer like down here trying to like yell and they're just like closing the window and going to sleep. Now you're up here and they're down here and they're like, fuck, what's going on? And now you're controlling the situation and you're forcing them to apply that endorsed bill of exchange as a payment on the account to settle the account.
Absolutely. Well, that's what I'm willing to do. I'm willing to take that step. Now, let me ask you this. You may have worked with people that have been in this situation before or not. I don't know. But when you sue someone, when you sue a bank over a car loan in this particular situation, when litigation begins, does that freeze like any attempts they have lawfully to steal the vehicle? I mean, that's what it is. I don't think I can say repossess because it's stealing at that point.
The answer to that question is no. I originally thought the answer would be yes, but now that I've actually seen so much of it, the answer is very much a no. You can file into the case a stay, like a temporary restraining order. And you can actually send it. We did a little bit of this on this like little tiny state case that we did in Texas that was like it was very chaotic and it was just like a blur to me. But you can file in like a temporary stay or restraining order. I mean, you could even file that in as part of your original complaint. You can have see attached emergency stay or restraining order, and then it would have a restraining order. So basically the way that litigation works is you let's say you want the court to approve a temporary restraining order. You write why you need the restraining order and then an attached proposed order. You'll see that all over my cases and all through recapping. It's just like normal procedure, right? So it would be like, there is a, blah, blah, blah on the payment of this. I sent in this payment. Here's the evidence, blah, 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 blah. And I hereby request that this court grant a temporary stay on repossession of this vehicle until the following facts can be, well, however you want to say it. And then there would be an attached order. You write the whole order to the point where all it has at the bottom is just a place for the judge to sign. And the judge reads the information as to why the order is necessary. The order is already written. You've already written the whole thing for them, and all they have to do is just take their pen and go chit 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 chit, and that's it. And then it goes on the docket, and then now you have an actual stay order. So I'm learning all this as we go forward. So like, there's a lot of things that are coming up now that are going to be implemented here soon, and there's a lot of things that weren't done before. You can look through all my cases to see all the wrong ways to do things, to be honest with you. we're getting there. We're getting there. You know, it's like, to become a world-class litigator in less than a year. I thought it was going to be possible. It's not. Okay. I'm sort of like trying to blaze a path, because I don't really have access to a lot of people doing what I'm doing. So I feel like I'm the one in the front, like, just like, fuck it, try this. It's just throwing shit in the air, which is super fun. I'm not complaining. But what I would do is I would try doing some kind of like a temporary stay order or restraining order or something like that included with your complaint. I don't know exactly how that would all work. You'd need to do a little research on that yourself. I haven't done that. But now that you're asking me, and now that I'm thinking about it for like the 4,000th time, that's probably how I would do it. For example, on my Glendale Water and Power case, I put right at the top of the case that I will be continuing to pay the account using irrelevant and extraneous negotiable instruments called Federal Reserve notes. So you can do it that way too. But it just depends on how you want to do it. It depends on how hard it is for you. I could put in a temporary stay into my Glendale Water and Power case, which was just dismissed. I actually shouldn't have gone to federal court with it. I'm going to go to state court, and I'm going to do it in a different way. I'm going to send in some new bills, and I'm just going to I'm rebooting that whole lawsuit from scratch. But I don't really care enough to try to put a temporary stay on my utilities. But I guess I could. Maybe I will. Maybe I will, just to test it out. It's kind of a cool idea. But something like a car, I would definitely put a temporary stay on it. Or the lowest risk, if you guys, is just put at the top that you're going to continue to pay normally, and then part of the relief at the bottom of it is that all those payments that were made were all refunded to you. So if you win the suit, everything gets refunded to you. Plus you get all the damages and everything else that you're asking for. So you can do it that way too. But from my experience, if you don't explain it or do something with it or whatever, they'll just come and take whatever. They don't care. They're just like pirates, basically.
Yeah. As you were saying that's what I think I'm going to do. I'm going to go, I have 2 days until they classify me as someone they want to come pirate from, right? So I'm going to go ahead and perform with these Federal Reserve notes to extend that out, and then in the meantime, I'm either going to file a TRO, temporary restraining order, with the suit, or do what you just said, which is just continue to send in Federal Reserve notes until the suit is done. Because, like you said, it's not even just taking a free car, right? It's getting paid to take a free car.
Correct.
There's going to be a lot of damages here, and
there's a lot of people who are like, "Oh, you guys are getting free cars," and I want to change that mentality, because the thing is we're actually getting paid to take free cars.
Yep.
It's a
so
much more.
Don't do this if you're listening. If you expect to just get a car and actually not hand over any federal, I mean, I was kind of hopeful about that. I was like, man, it'd be cool if I could figure this out and then just literally never have to hand over any Federal Reserve notes. I was prepared to do it if I had to.
Yeah, and on this point, we had another case. There was a case where the defense actually filed an emergency stay order, and they actually emailed it. So if you go online, like on the federal cases and so, you can find the email and sometimes the phone number for the judge's chambers. And if you have like an emergency stay order, like for example, let's say like you're paying on a car, but like they still come and try to repo it, and like you catch the guy, and then you can actually write up an emergency stay order, and you can actually email it straight into, there's like certain rules and stuff. You can email it straight into the judge's chambers, call the judge chambers and be like, hey, I have an emergency stay order. I need this thing done. And I've seen those things get signed in less than 24 hours. If you have ongoing litigation and you're like in the middle of a case. So you can do stuff like that too. Let's say you're paying with Federal Reserve notes, and then let's say one day like something bad happens, your mom gets sick or something, and then you can't pay with Federal Reserve notes anymore. You can slam an emergency stay order into the case, and that'll prevent them from repossessing the car if it gets approved for the duration of the. Now you also got to think too, like if you write an emergency stay order, how would it be written? Would it be written like for this case? Because what if the case is dismissed and then you go to appeals? So I don't know if you can write in the stay order like this would include any appeals cases. I don't know. You would need to go into
go look at how other people have written them.
You would need to go see how other people are writing their cases and see, because ideally that would be ideal. Because I'll tell you right now, it takes fucking forever to get through a case and then go all the way through appeals too. You're talking about years. So typically. So the thing is that you could hold on to that car for a year and a half without having to worry about anybody taking it, if you can get the stay order to survive through appeals. But if you start doing stupid shit and you go to appeals based off of fucking nothing, then they can sanction you, and it's called frivolous, which means that it had the intent to harm or harass. So you never ever want to do that. That's very bad. You're going to end up paying a whole lot more.
What is the stupid stuff you don't want to do? What are we talking about?
Like if a case is dismissed, like I've had cases dismissed, right? And it's like I actually really get it. You wouldn't go to appeals for no reason, like just to be an asshole or just to flex your dick or whatever. You wouldn't just go to appeals so you can hold on to your car longer. Basically, if the stay was approved up through an appeals case, you would want to make sure that whatever it was dismissed on, you have to. I'm learning a lot about this too. I'm new into the appeals courts. We have 2 appeals going on right now. So, yeah, it's all part of the learning process. I mean, I could sit here and talk all day. It's just all part of the learning process. You're going to learn how to write a notice of appeal, a notice of intent to appeal, and then you have to pay a different fee, and then there's a special appeals case that opens. So the way that appeals works is you have the first case, and then you have the appeals case, and it's considered 2 different cases, but they're not operating at the same time. It's sort of like your case goes to the appeals court, they look everything over, and then they're going to like write whatever recommendations or reboot the case or whatever you need to do, and then it gets sent back down to the original case typically, right? So it's 2 case numbers, but it's really just one case being moved from location A to location B temporarily, and then at location B, if it gets remanded back with instructions, it's going to go back to location A with instructions from the appeals court, right? So
okay,
you're really always in one case, but it kind of looks like there's 2 cases. So you'll learn all this as you go. You know, it's not very expensive. You can do what's called informa pauperis. I don't do it myself, and I don't recommend it because there's particular sections of the Constitution about paupers. It's not great, but you can actually file lawsuits for free if you want to. But if you can pay for them, I think it's better to pay for them.
Yeah, I've looked at a little bit of informa pauperis. It doesn't seem like the move. Well, Brandon, thanks so much, man. What I think I'm going to do here, just for everyone listening, I'm sure there's someone else out there with a car that's like, man, what do I do? What I'm going to do in this situation is go ahead and send over some Federal Reserve notes, get them off my back, because they're coming for me in 2 days. They're coming. They're going to be knocking down the door. Get them off my back for a minute.
You could send your bills to the Treasury, and then if the Treasury does not perform on the bills, you can actually sue both the Treasury and the financing company.
Yeah, that's something.
The Treasury is supposed to be paying for your
like
truck.
100 different ways to solve this equation. It's
you could just that same location we saw on the IRM for the IRS bills. You can have a cover letter, and you can say, you can send one copy of the bill to the Treasury, and then you send another cover letter to the finance company and tell them that the Treasury is going to be taking over the bill. And then just make sure everyone's on the same page, and make sure you tell everybody. And you can even pay with Federal Reserve notes for a month or so that you have enough time for everybody to get the communication and everything. And then you call up the Treasury and you say, hey, did you guys pay that bill? If they didn't pay it, you call up the financing company. Hey, did you guys get that thing I sent you? Okay. If they're not paying it and they're not working with the Treasury, you can sue them both. So you would have 2 defendants. It'd be defendant number one would be the finance company, and defendant number two would be the Department of the Treasury. And it would be basically a lawsuit for it's all the same thing. It's these bills are fall under 18 USC 8 obligations or other securities of the United States. I endorse them and sent instructions to the Treasury. The Treasury is not performing. So the whole point of the lawsuit would be to force the Treasury to pay for their own obligations. It's not your obligations, it's their obligations.
Very interesting.
You don't own the truck, though, either. So keep in mind, you don't own the truck. So when you get pulled over because a police officer pulls you over, a police officer is a private security force on behalf of the United States. They're policing their own shit. That's why the police can pull you over. So my car, it's not a very good example. Your car, you can get pulled over by the police and you can get tickets. Now, the tickets are also obligations or other securities of the United States.
Yep, the
ticket would also go to the Treasury, right? But if you own your own car and you're in the private and you don't have a certificate of title on your car, the cop can't pull you over. He can't do anything, and if he pulls you over, you can sue him for a breach of civil rights under color of law, which would be 42 USC 1983. And then if there's more than one police officer, it'd be a conspiracy charge, which would be 42 USC 1985. The cool thing about a 42 USC 1985 is there's actually special jurisdictional things associated with federal lawsuits when you start getting into 42 USC 1985. I found it just recently. It's like a special extraterritorial jurisdictional thing. So you can get like crazy jurisdictional access when there's more than one police officer. But it would have to be your car. So it wouldn't have a certificate of title. If it has a certificate of title, it gets complicated because the police are just policing their own shit. Mm-hmm. Mm-hmm. State of California owns your car. The police is a private security force for state of California driving around issuing commercial tickets to people.
And they don't know either. I mean, this isn't like going against the cop. That cop has no idea what's going on.
So the thing is that you can sit there and say, cop, give me all the tickets you want. What's your quota for the day? Give them all to me. You don't need to do anything with your title. Leave it alone. Take all the tickets, cover letter, endorse all the tickets, cover letter to the Treasury. If the Treasury doesn't perform, now you're going to sue the police station. You're going to sue the police officers, and you're going to sue the Treasury, and then you're also going to get the SEC involved. Because now we have securities. You're trying to perform on these securities. You're trying to perform. And if they go to the Treasury endorsed without recourse, they can never come back to you. You're literally washing yourself of the instrument entirely when you use without recourse. So now if you do without recourse and it goes to the Treasury and now they're coming after you and making a bench warrant on you, now you can sue the court in the Court of Federal Claims. You can sue the police officer. You can sue the Treasury, because the thing is that it was without recourse. They can't bother you anymore. You cannot be bothered. Now you got to think: does the court know this? So you would put in a motion to dismiss, and you would attach the cover letter and the fact that they received it and any additional letters that was received, and you would say no. Motion to dismiss. This was already endorsed and tendered to the Treasury to be paid under an obligation or other security of the United States. Here's all the evidence. And when I endorse those instruments, I endorse them without recourse. So I actually don't have any financial responsibility to pay any of these at all. And I motion this court to dismiss the case. How can you expect the court to know that you already performed on the instrument and you already released all liability on the instrument by endorsing the instrument without recourse? They don't know what you sent the Treasury.
Yep.
So you can even inform the court and send it in preemptively. Hey, just want to let you guys know, I am going to be paying the fees on this. Here's everything that was sent to the Treasury. Everything was endorsed without recourse, so you won't be calling me anymore. The people you're going to be calling is the Office of the Executive Director, room 3413. And you can put the phone number on there. If you guys need anything associated with getting these negotiable instruments discharged or paid, please contact room 3413 at the Treasury, because they are now the ones financially responsible for this obligation or other security of the United States.
Beautiful. And there's so many different ways to navigate this space. That's what I'm starting to learn.
Enforcement is where everyone falls down. That's kind of how my name has gotten so big and why my platform's so big. I'm like the guy trying to figure out the enforcement end of everything. Everyone ignores you and calls you a sovereign citizen. So how do you get the government to follow their own laws? The only answer I could figure out was litigation. I didn't know, nothing else seemed to work. You can send all the letters till you're blue in the face. You can call them all day long. It ain't a new fucking goddamn thing at all. It ain't do shit. So,
yeah. And that's the other stuff was easy. And now that litigation is literally on my doorstep, it's time to nut up or shut up. So, man, thanks for all the resources you provide. I am looking forward, weirdly enough. I am nervous, but I am looking forward to the next steps. Starting never thought I'd be saying those words. I'm looking forward to a lawsuit, but here we go.
Well, it's a lot of fun when you're the plaintiff. It's a lot of fun when you defend that too. Nobody ever sues me. I'm kind of lonely, so I sue everybody else. When I filed my first lawsuit, I was very nervous. So I think that's kind of part of the process. Every single lawsuit since then, 90%.
How much does it cost to
less.
file a lawsuit in California? About
Like
400. $400.
It's the same as for people who are out there too, you've also got small claims. Small claims is like cheap, hot, fast. So if you have like a smaller amount, like for example, I thought about taking my utility bill stuff to small claims. Small claims is like fucking hot, fast, cheap. I might do that. We'll see. But there's certain things. I think it's like less than $17,000. You can go to small claims.
Really?
You can even represent a corporation in small claims, I believe. I was doing some research on that.
Like half of the principal on a vehicle loan to a small claims court.
Yeah, and you can sue. Let's say you can take a vehicle to small claims, and you can say I was trying to perform, and let's say the maximum for small claims is $17,000. You want $16,999. That's just damages. And then you also want a court order forcing them to perform on the instrument. So you can get your relief in small claims. Small claims like $80. And the cool thing about small claims, I'm trying to remember, I'm pretty sure on this, in big boy court, you have to have an attorney at law if you have a corporation or LLC or something like that, right? So you have to hire a bar card. You can't represent an LLC, a corporation, S corp, partnership, association, fund, foundation.
You can't pro se?
No, not a separate entity like that. You can only pro se your own name in all capital letters, which is a sole proprietorship. You can only pro se a sole proprietorship, basically, right? In small claims, from the research I've done, you can represent another entity in small claims. So let's say, for example, you have an LLC, and the LLC is trying to pay some bills using the treasury or whoever. You can sue in small claims without an attorney, and you can represent your own LLCs, S corps, and partnerships. If I remember correctly, I haven't gone down that rabbit hole too deep, but I remember seeing that, and I was like, "Oh, it's fascinating." Small claims, there's no trial and there's no discovery, I believe. I haven't done it myself, so it's like a fast, hot, cheap, and like all the shit that takes forever is all taken out of it. So I honestly am starting to think, I don't know a whole lot about it. I'm starting to think small claims might be a great first step for people that are really nervous about litigation, and it's sort of like they want to take that first bite, right? And then in terms of, I would assume you could still put a temporary stay into small claims. I don't see why you wouldn't be able to. And then in terms of what type of litigation, if you sue anyone, you can continue to pay with Federal Reserve notes. That's super easy. Or something like student loans would be a great place to start, because student loans, there's no real liability attached to student loans. You got nothing to lose. You literally can't fucking lose. Okay, the highest risk would be like a home mortgage, but like I said, you can continue to just pay the mortgage and then sue at the same time while you're paying the mortgage.
Yep. Well, Brandon, we're about out of time. It's going to cut us off in like 2 minutes here. But
Sweet.
thank you for being on the show, man. And I think we covered some topics that we covered some good stuff to give a foundation. We covered some new stuff. Hopefully, people out there that have been getting these cars can learn. I don't know. Just have me as a data point. Take that as you will. Do whatever you want with it. But yeah, thank you for coming on, man.
Sweet,
You
man.
have a good rest of your night.
You too. Thanks, guys.